You are both tenants in a landlord-tenant case, and you're defendants in a case that demands that you pay the rent. In such a case, you have the following legal rights. You have the right to obtain counsel in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. We sent you that information, and Meg Bauer from Western Michigan Legal Aid is here with us on the live feed. You have a right to have the case heard here in St. Joseph County. You have a right to demand a jury trial. You have to do it today or do it in writing within 5 days and pay the $50 jury demand fee, unless you can't afford it and you ask for a waiver and the judge waives the fee. And we will either tell you where to find that form or provide it to you. Your landlord has asked you to be evicted from a residential property because you haven't been able to pay the rent. You may be able to get assistance from the Michigan Department of Health and Human Services, the local coordinated agency, a housing assessment and resource agency, or a federal homeless veteran program. I just talked to a lady earlier this morning that had contacted all of those agencies, except the veterans one. You should have received that information regarding that with your summons and complaint, and I did send you that. You may be able to reach an agreement with your landlord if the landlord is agreeable by going through an alternative dispute resolution. So far, that's never happened, but it might. And we would refer you to the Citizens Mediation Authority or Citizens Mediation Services, Inc. If you do reach an agreement with the landlord, that means the case gets dismissed. There would be a form called a conditional order of dismissal that could be filed with the court. We would either provide you with that form or tell you where to find it. So let's start, Ms. Sprague and Ms. Pennington, with the basics. What is the current arrearage?
Currently, we do show that there is past due rent in the amount of $3,546.70. There are currently costs of $205 for court costs. That is not inclusive of the service fee, which we have not received yet, for a total due of $3,751.70.
There is no proof of service in here, but the defendants are both here, so I guess I'm not going to be concerned about that.
I called the courthouse and got paperwork.
Oh, did you? Well,
yeah,
you're
I
here,
never received
so,
nothing.
Well, I don't see a proof of service, but you're here, so that's not an issue. I'm not going to charge you for proof of service if they didn't serve it. Anyway, this is a non-payment of rent. If you don't pay the rent, you could be compelled to move. Ms. Goodsell, you don't care because you've already moved.
Right.
Mr. Goodsell, this is of concern to you. Now, Ms. Pennington sent you a letter regarding that, and their concern is your income alone is not going to be enough to pay your rent. Mr. Goodsell, have you asked for any emergency assistance?
No, I don't know how to go about all that stuff. I just called the welfare, and that's how they set me up with my lawyer.
You have a lawyer?
Judge, let me chime in if that's all right.
Yes.
Mr. Goodsell did contact our office. I've got about, I don't know, close to 800 pages of paperwork that I've been going through. This case is actually a mess. We have not entered a retainer agreement with Mr. Goodsell, but I did uncover last night a little bit of ambiguous communication from our support staff, creating the representation, or, impression that we may be representing him. So being aware of that, I certainly understand that reliance on him and want that to be to his detriment. But this case is quite complex. There's a number of properties involved. They've lived in 3 properties, 3 units while living there. They were subsidized, and I can't figure out if or how they ended up not being subsidized anymore, or why they haven't recertified him based on Ms. Goodsell no longer living there. Nor have I seen a ledger, actually, so I'm not entirely sure what's going on here, but this case is actually quite complicated, and I haven't heard from Mr. Goodsell in quite a while. But he did contact my office, and we have been trying to uncover or investigate this.
All right, well, Ms. Pennington, maybe you can help me a little bit. They've been in this unit at least since last October,
Correct.
which is apartment
903.
903. So Cheyenne left, and Ora, you've been in 903 since that time?
Yes, sir.
All right. Ms. Pennington, when was rent last paid?
I'm sorry, Your Honor, I did not have that right in front of me.
I do
Well,
show the ledger, Your Honor, if I
all
may.
right. Yes.
I do show that there was a partial payment that was made in December. It looks like the last time that they were current on the rent would have been in November of 2023. And then there was a partial payment of $333 that was made on December 5th. Their rental rate is $726.
My paper is 760.
What was pled was 726. So there, you're right. There's a bunch of issues here. Mr. Goodsell, you haven't paid any rent since December. So that's obviously a problem, no matter what the rent is. You can't just stay there without paying any rent. Did you ever ask for a recertification?
I figured that I thought that once that Cheyenne gave her all the information that she needed for her to move, that they would redo my thing for my disability.
Well, Ms. Bauer hit the nail on the head. This matter's complicated. We're gonna need to adjourn this. Now, Ms. Goodsell, you don't care about being evicted because you've already moved. You could, however, be liable for money damages if they end up saying, hey, you owe us $3,000. Your name's still on the lease. So you do have an interest in this.
I gave my 30-day notice and everything, and I don't even have a job.
All right, well, we'll see. But Ms. Sprague, you have any input on this?
Your Honor, I would just like to note that the unit that they are currently in is not a subsidized unit. So a recertification is not going to impact the amount that they're currently paying. They were made aware of the fact that it is not a subsidized unit prior to moving in. It's my understanding, Ms. Pennington, you can correct me if I'm wrong, but the unit that they were in was part of a fire on the property.
Correct.
And that
Correct.
was a subsidized unit at that time. However,
It was not.
oh, it was
at
not.
that
My
time.
apologies. It was not. So that is why they were relocated then, was due to that fire. So it was an unsubsidized. Both Ms. Goodsell and Mr. Goodsell signed that lease agreement. As a general practice and per the terms of the lease, they aren't able to provide just a 30-day notice in the middle of the lease to vacate unless they are in good standing, and the remaining tenant would be eligible to remain there on their own. And as the letter that you have in front of you indicates, that those parameters were not met when Ms. Goodsell left, which is why she is still a party to this case regarding.
And Meg, you don't have that letter, so I will send a copy to you.
And Meg, if you want to send me your email, I'd be happy to send a ledger and Your Honor, I have a copy of that as well. I can do that to relieve the court of that burden.
All right, very good.
So the letter and the
let's-
ledger, and then
So this is just a traditional unsubsidized lease and no one's paying the rent. Mr.
Correct.
Goodsell, if they get what they ask for, you're gonna have to move or pay the rent. So a couple things. You've talked to your caseworker. I would get with DHS, not Keystone, Neighborhood Inc. or Community Action Agency or somebody to see if you can get some emergency assistance. But as Ms. Pennington points out in the letter, you can't afford to live here. You don't have any income. It's not a subsidized unit, and your co-payer left. So you're in a tough spot, but I'm gonna bump this out.
Your Honor, if I
Yes.
may, there is a timely issue at hand in the fact that there is coming up a subsidized unit that would be available that Mr. Goodsell would have a priority for if he were in good standing. And so I understand the court's discretion of bumping it out so that he can try to gain resources. However, my client can't hold that indefinitely. And if I know Meg has indicated that she's spoken, she has not been formally retained, but if that's something to where she could work promptly on getting at least commitment letters regarding that balance, we could see if we could work something out to where he would be able to move into a subsidized unit in good standing with a payment plan in lieu of a straight eviction, which is what we would be compelled to do at the
All
next.
right, well, thank you for bringing that up. If you can get this rent paid, you got priority for a subsidized unit in the building. So I'm gonna bump this out 2 Fridays.
I just wanted to make the court and Mr. Goodsell aware of that option because that would, given his financial dynamics, that could potentially be an option, an opportunity that might not
Very
otherwise be
good.
if we wait too long.
As you know, we're dealing with people, not just numbers or pieces of paper with letters on it. These are real people and real lives. So I appreciate your presenting an alternative here that could continue to provide housing for Mr. Goodsell. All right, Mr. Goodsell, you need to get on your horse. Ms. Pennington, you want to add something?
I am not available on May 10th. I am in a conference all day.
All right, Ms. Sprague, can you do it without her, or do you want me to pick a different day?
Ms. Pennington, do you have a problem with me presenting the facts at that hand?
I do not, but I did want everybody to be aware.
All right, I appreciate that. All right, we're going to continue this to May 10th. Mr. Goodsell, you need to contact legal aid.
Okay,
And you need to contact these other agencies. If you can get your rent paid, they can release Cheyenne from this. They can close out the tenancy on 903, get you in a different unit, and get started.
I don't think they have any wheelchair accessible units.
We-
The one that I'm in right now, I'm in a townhouse, 3-bedroom upstairs, which I have no use for because I can't get upstairs because I'm in a wheelchair. I can't walk.
Well, I saw that, and so that's what they're working on. You're taking up a lot of space. Somebody else would love to have this 3-bedroom unit. They've got a waiting list.
Yeah, because the only thing I have use of is just the kitchen, and my recent injury was the last Sunday when I went to get out of my wheelchair to go to the bathroom. I fell and twisted my ankle because I can't walk.
All right, well,
It's beating me up so bad. With the ramp, falling down it, ending up in the hospital. And that's.
well, you could always move somewhere else if you don't like it there.
That's the problem. I don't have nobody on my side anymore. Nobody comes and visits me. I'm on my own now.
All right, well, you're gonna need to take some action.
I've been
So,
trying to do that.
all right, well, we'll revisit this on May 10th. You need to call legal aid.
I most certainly will.
All right, thank you. And Ms. Sprague will provide the ledger and the letter to legal aid.
And Meg, I apologize. I don't see a chat option. Is it possible to get your email? Is that something
Yeah.
you're comfortable with?
Yeah, I was just looking you up on Relia Guide, but I have no problem putting my email out there. It's M Bauer. It's B as in boy, AUER at lawestmi.org.
Okay, thank you. I will get that sent over shortly.
I appreciate that, Attorney Sprague.
All right, thank you both. Keith, how about 10:30?
I can do 10:30 on Zoom.
I have a 10, some 10s and an 11, but I think I could fit that gentleman in at 10:30.
I'll log in at 10:30.
All right, thank you. All right, thank you all. All right, this next matter is LC Arrow and Email Holdings versus Jack and Stephanie Nichols. This is a property on West Chicago Road in White Pigeon. Mr. and Mrs. Nichols, can you hear me?
Yes, we can, sir.
And Attorney Ryan Buckland is here on behalf of this property. Is anyone here on behalf of LLC Arrow?
Yes, I am. I'm the property manager, Jessica Thornton.
Okay, let me note that. And I've got Jason's note. Which case are you on, sir? Jason's note 20 Ultra.
Oh, I have sound now. I'm sorry.
What's your name, sir?
I am Jason Moore. I am Earl David Moore's son.
Are you here on the Fulton Road property?
Yes, sir.
All right. All right, we've got two tenants here, or representatives. Good morning, Mr. Schulte. Can you hear me?
Yes, I can. Good morning.
And good morning, Mr. Grant. We'll be with you in a bit when we finish these landlord-tenant cases. It looks like you're inside a soccer ball or a very elaborately tiled restroom. I'm not sure, but anyway, welcome this morning. We're going to take care of these two landlord-tenant matters, and then we'll address our general civil cases. You're each defendants in a landlord-tenant proceeding. One, the Fulton Road property is a mortgage foreclosure. The other case with the Nichols is a non-payment of rent. As such, you have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you, and Meg Bauer from Legal Aid is here on the feed with us. If the action is for non-payment of rent, you may be able to get assistance from one or more sources, including the Michigan Department of Health and Human Services, a local coordinated agency, which would be
Community Action Agency.
Community Action Agency, a housing assessment and resource agency, which is Neighborhood Inc., or a federal veterans program if you're eligible for veterans benefits. The case must be heard here in St. Joseph County. You have a right to demand a jury trial if you wish, and if you do wish a jury trial, you have to tell me today or make the demand in writing within 5 days and file the $50 jury demand fee. We will provide you with that form if you need it, and if you're unable to pay the fee, you can ask the court to waive that $50 fee. If you do reach an agreement outside of court, you may be eligible to file a form called a conditional order of dismissal. And we can either provide you with the form or tell you where to get it. And finally, if you're able to agree with your landlord to have the case referred to mediation, we can send the case to the Citizen Mediation Authority to try to work out a mediated settlement. But let's start with the Nichols case. This is a non-payment of rent case, and Mr. Ryan Buckland is here. What's the arrearage at this point?
I was informed that the arrearage is $4,750, and that's inclusive of any late fees.
That's through April?
Correct.
Ms. Thorne, you agree with that?
Yes.
All right, let's talk about court costs. We got $55 filing fee. I can't see the service fee. Can you tell me what you've got for costs?
I can. I show a $55 filing fee and then a $108.28 process server fee.
And the $75 attorney fee.
Correct. So I have that totaling $238.28.
$4,988.28. Can you tell me, either of you, Mr. Buckland or Ms. Thornton, when was rent last paid?
I probably defer to Ms. Thornton on that one.
The last payment I got from them was $100 back in January. He's been behind since, I believe, September of last year. I only have the weekly sheets, and I turned those in to my boss, so I don't have like.
All right, well, let's find out. Mr. and Mrs. Nichols, what's your position?
Right now, we got a DHS working on paying it for us right now. It's in process.
All right. Now, They have to pay the whole thing. This is almost $5,000. And each week it goes up another $270. So this is expensive. 270.
And they add a $50 late fee per week too, sir.
Yeah, I'm not sure I allow $50 a week, but
That's what I've been paying.
times
That's why I was
52
behind.
Divided by 12, it's $1,170 a month. I don't think you can do a $50 late fee on a week-to-week tenancy, but that may be something that'll have to be determined. Anyway, you're way behind. And are either of you working?
Yeah, we both just started working 3 weeks ago.
Do you have any tax refund coming?
No.
No, we don't. We have to file multiple years because we haven't filed in a while, and it's going to cost us some money to get that done.
Well, that's a separate problem, but yeah, the deadline for that is already passed. All right, well, let's pick a date. This is a substantial arrearage, and it's just going to continue to get bigger. But in light of the fact that you are asking for financial assistance, I'm going to adjourn this more than 10 days. I'm going to adjourn it more than 7 days. I'm going to adjourn it 14. I'm going to continue this to May 10th at 10 o'clock. Ms. Thornton, have you had any contact from DHS or anyone else?
No. And may I just ask if they got jobs, both of them 3 weeks ago, they have not made any effort to pay anything.
Because we had made an original agreement and you guys backed out of the agreement. That's why you haven't gotten any money.
Well, our first two paychecks, the judge
All right,
went
well,
to
stop. This is stuff you can discuss privately.
Okay.
I want to stress to you, Mr. and Mrs. Nichols, you have to pay the entire amount of the rent. So let's say by the time we get here 2 weeks from now, this is up to about $5,600. And DHS says, we'll give you $4,000. You would still owe an additional $1,600. And unless you pay it, you'd be subject to being evicted 10 days later, which would be May 24th. So any payments you do make certainly would be credited to the arrearage. But
Okay.
it would be unusual if they give you that large of a chunk of money, but it's happened. And if you're both working, then maybe you can get squared away. Anyway,
Yeah.
because you are working with DHS, I've been continued at 14 days rather than 7.
Okay.
Okay.
So I didn't ask, Mr. Buckland, is that date and time okay for your schedule?
I can make that work, Judge.
All right, thank you. All right, now you need to do 2 things. You need to stay in contact with DHS or any other funding agency like Neighborhood Inc. You may contact them also. And
Okay.
stay in contact with your manager. But let me repeat, the only thing that cures this is paying the entire amount.
Okay.
All right, do you have any questions?
No, sir.
All right, I'll see you all in 2 weeks.
All right. Thank you.
Miss Munson, can you hear me?
Yes.
So this is a continuation of a landlord-tenant case, 231926LT, Roxana King versus Madison Nelson. This is a property, I think is on 9th Street in Three Rivers. Mr. Howard Bush is representing the defendant. Maybe I got the wrong address. I better look at the complaint.
I think you might.
At any rate, Mr. Howard Bush is here on behalf of the plaintiff, and she is there with him. Let me pull up the original landlord-tenant case.
The property is in the village of Constantine also.
It was already in my queue. I didn't need to do a secret search for it. We had a hearing in January, and it was a termination of tenancy. The defendant agreed to move by January 29th, and defendant will remove property. And she had until January 29th. I noted no money judgment was entered at this time. And the property, well, everything says 9th Street. Let me get to the actual complaint.
It's in village of Constantine, not Three Rivers.
Oh, it says 705 9th Street, Three Rivers. Let me get the actual address of the property.
I believe that's where the defendant might be presently living.
Yes, it was an upstairs apartment at 157 East Water Street.
That is correct.
All right. Anyway, the plaintiff has alleged a substantial amount of damages, rent of $5,200 and other damage, including trash, cleaning, and smoke alarm, for a very large total. So let's start by swearing in the parties. Ms. King, would you raise your right hand? Ms. Munson, would you raise yours? You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
I do.
All right, thank you. Ms. King, let's start with you. In your complaint, you allege that the rent was $650 per month. She hadn't paid any rent since May of 23 for 8 months of rent, which would be $5,200. Is that correct?
Yes.
And you also allege that there was $106 for trash removal.
Yes.
Tell me about that.
That's how much it cost at the landfill for the trailer full of garbage.
All right. And then it took 16 hours to clean it and load that trailer. So that's $250.
Yes.
All right. 250 divided by 16 is $15.26 an hour. How'd you come up to that figure?
That's just the bill they gave me.
All right. Who did the cleaning?
J&J Handyman.
And then you had to replace a smoke alarm for $52.
All the smoke alarms, I think there were 3 of them in total. They were all gone.
All right, so if we add that all up, it is $5,608. You indicate she did have a security deposit of $650. Is that right?
Yes.
So that brings the total down to $4,958. And we add in court costs of the filing fee, service fee, and Southwest legal and attorney fees. We get $256.06. For 958 plus 256.06 is the same figure Mr. Bush got, $5,214.06. That's the amount you're asking for?
Yes.
All right. Ms. Munson, the largest component of this is rent. No rent from May to January. What's your response to that?
I have no response. I know I messed up. I know I did not get my stuff out in a timely manner. I admit responsibility. I mean, I can't put it off on anybody else.
Where are you calling from? Where are you zooming in from?
I'm at work currently.
Okay. Well, we'll get you back to work. All right. Thank you. Howard, I'm looking for an order.
I believe I owe you one.
All right, okay. All right, well, let's talk about this. We just realized that I started the record. I started the live feed, but this is Roxana King versus Madison Munson, 231926LT. It was a landlord tenant case with a consent judgment in January of 2024. Roxana King is with Howard Bush at his office, and she was sworn under oath and supported the data pled in the supplemental complaint. Madison Munson is at her place of employment. She was also sworn and essentially acknowledges the debt. So the judgment is for $5,214.06. That's $4,958 in damages. That was the other damages less the $650 security deposit. with court costs of $256.06. Everything matches exactly was what was in the complaint. Ms. Munson, are you able to make any monthly payment?
Yeah, I can. I'm just not sure how much.
Well,
I'd have to
this
go
is
through and
large.
figure.
It's 52. Now, they'll now have a judgment. And Mr. Bush can use the judgment to garnish your wages, which you won't like very much. They'll take a substantial amount of your net pay, or you can try to set up some sort of monthly payment plan. A debt of this size, I would look for at least $200 per month. What's your response to that?
I honestly, $200 a month, I can honestly probably swing that, but anything more than that, it would probably be a struggle.
Mr. Bush, is that acceptable to you and your client?
Yes, Your Honor.
All right, Mr. Bush, I'd like you to, we'll call this a consent judgment. If you would send me a consent money judgment in the amount of $5,958, $256.06 for a total of $5,214.06, just as you pled in your complaint, payable at $200 per month to your client beginning June 1st. Ms. Munson, I hope you're in a better place, both emotionally and financially. It sounds like you got a good job. And a new place on 9th Street. And I hope this works out. So do you agree to pay that amount at $200 per month?
Correct. I just need to know, who do I pay it to? Do I pay it to
You pay it
Mr. Bush?
directly to Rox. No, you want it payable to Ms. King. Is that correct, Mr.
Okay.
Bush?
Yeah.
Payable directly to Roxana King, just the way you used to pay your rent.
Okay.
All right. He's going to send me a copy of that. I will sign it and we'll send it to you as the
Is
9th Street address,
the
correct?
regular judgment form?
Well, you can use the landlord tenant form with the
Okay.
money judgment in it.
I will submit.
All right, Ms. Munson, I'll let you get back to work. Do you have any questions or concerns?
Nope, that was it. Thank you.
All right, I appreciate your candor here. You're good to go.
Thank you.
Mr. Bush, thank you. And Ms. King, hopefully $200 a month will take about 2 years or a little more to pay that off, but it's 200 is better than none.
It's
All right, thank you.
Thank you.
We're back to Ryan Gillespie, which is 2324FY. Mr. Marvin is here, Mr. Gillespie is here from the Wexford County Jail, and Mr. Gibson is here. Mr. Marvin, what's the status here?
An offer was conveyed in its attempt joyride. The idea is to get this wrapped up, and at elocution, I'll tell you kind of the twists and turns of this one.
All right. Mr. Gillespie, you're charged with auto theft or receiving concealing, which is the same as auto theft. Sometimes it's known as UDAA, unlawfully driving away an automobile of another. I don't know why they made it so cumbersome. It's a felony. It's punishable by up to 5 years in prison. There's a lesser charge, which apparently you pled to in Wexford County, called unlawful use of an automobile, sometimes known as joyriding. That's a high court misdemeanor, punishable by up to 2 years imprisonment. If you cut that in half by making an attempt, as Mr. Marvin has suggested, it makes it a misdemeanor, punishable by up to a year in jail. You've just done 16 months of jail on a 1-year misdemeanor, so I can't even give you any more jail time. But it would resolve the case and the matter would be completed. Mr. Gibson, do you confirm the plea offer?
Yes.
Mr. Gillespie, are you going to plead to attempted unlawful use of an automobile?
Yes.
Other than what was said here, did anybody promise you anything to get you to plead to this?
No.
Or threaten you anything?
No.
All right, do you understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or a jury that will be no trial? Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you, representing you in this matter. Could also hire an attorney of your own choosing if you wish. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. So let's take a look at this thing. The allegation is that way back in January of 23, you received and concealed a semi-truck that you knew or had reason to know was stolen, and that you had previous felony convictions. At some point, were you in possession of this semi-truck?
Yes, I was.
Did you know it was stolen?
I didn't know it was stolen, but I know it became stolen.
And you had reason to know at that point it was stolen?
Yeah.
All right. I guess that's sufficient. It'd been stolen on a Cadillac. And then somehow you ended up in possession of it down here. Mr. Marvin, what's your position here?
I think it's important to explain how we came to this resolution, and it's a good lesson probably for people who are interested in how the law works. This is a case where somebody was caught with a vehicle that was stolen, charged with the same thing out of a different county, held in jail for 16 months, as you said, Your Honor, for something that you could not even have given him he could have had 1 year, so he spent more time than that. In addition to the time and effort that he spent, or the tax dollars that were spent housing him, he also had a competency review. And I don't know what kind of money that cost, but he went through the system to make himself restored, so he's now competent. So we're dealing with somebody who was deemed incompetent at the time this happened. I have a choice. I can resolve this today, and we already know that he spent more time in jail than the law would have allowed otherwise. Or I could insist that he come back down here, and then I can have my county spend money and go get him, bring him back, waste your time, my time, defense time, house him in the jail, take him upstairs and try to get a resolution upstairs and ultimately go to trial, hundreds, maybe thousands of dollars in addition when he already has served more time than he would have. For that reason, I'm offering this today, and I would like this on behalf of everybody who's reasonable and intelligent to just, he's already claimed responsibility, and I'm glad for that. But I think that if he needs continued help, he can get it. And I think we're done with him, Your Honor.
Well, Mr. Gillespie, you had a Florida address. Where is your home base?
Florida.
And I just came from there. It's quite pleasant there at this time of year. Maybe you have an out date from Wexford County?
Not yet. We haven't got that far in this case yet.
Well, I'm going to sentence you to 365 days jail credit, 365 days. And no fine, there's no point. So when you're done with Wexford County, where this thing was actually stolen from, you're free to get on about your business, but your stuff in St. Joseph County is resolved and you're good to go. So thank you to Wexford County jail staff for doing this on short notice. Mr. Gibson, you and Laura set this up while I was gone. We were able to do this. Attempted joyriding is 414, I think it is, for joyride. Mr. Gillespie, good luck to you.
Thank you.
You're good to go.
Thanks.
All right, Mr. Marvin, that, like I said, I just got here and that was laying here like a boulder in the middle of the stream. So we'll see where we're going to go with that, but at least our deputies didn't have to drive to Cadillac and get him. let's finish our arraignments and then we'll address the PECs. Mr. Turner, would you come back up to the podium, please? This is file number 24570OT, People versus John T. Turner from Elkhart. Mr. Turner, you got a ticket for driving suspended, which is one of our most popular crimes. We get hundreds of these. Once upon a time, there were 31 ways to get your driver's license suspended. I don't know how many there are now. They've removed some and added others. You got this ticket in Three Rivers on April 6th at 9 o'clock. Portage and Tulip Lane. Driving suspended. You're an Indiana driver. Let's take a look at your driving record. Not licensed. Doesn't show a suspended. Did they charge us?
Yeah, I actually have it back now and I have proof that the ticket was paid. My BMV just kind of fumbled it. So I had to take it upon myself to like contact Indianapolis and stuff and get it back.
All right. I'm going to have you meet with the prosecutor and you can share that information with him and see what he can determine.
Okay.
It means you weren't here totally futilely this morning, so you'll accomplish something. So this is Mr. Tim George from the city of Three Rivers. He's going to meet with you and look at your information.
Okay.
Yeah, sure. Here's what his Michigan driver's record shows. Just shows no license. Doesn't show a Michigan suspension. All right. Well, we've got Mr. Gibson in the waiting room.